This is a current tense case brief presentation on a civil case which deals with the application of the Human Rights Code. The citation of this case is Cooper and the City of Toronto 2013 HRTO 9. The applicant Robin Cooper was employed with the City of Toronto in 2005 in the Solid Waste Department as a recycling truck driver and loader. In February 2009, the applicant experienced a workplace injury and left work for 30 weeks. Accommodated work was offered according to the driver-loader agreement between the City and Toronto Civics Employees Union. However, the applicant asserted that the City did not provide him with accommodated work from February 26 to September 23, 2009. On September 19, 2009, the application 2009 allegations was filed against the City under Section 34 of the Human Rights Code, asserting discrimination because of disability with respect to applicants' employment with the City. On March 8, 2010, the union filed a policy grievance on behalf of drivers against the City, asserting that the City violated the code by terminating the accommodated work that was originally provided to driver under the agreement. In the February 2010 work selection process, the applicant chose the position of ticket collector at Rouge Raleigh Campground and was asked to complete the ticket taker assessment. The applicant, however, indicated in March that he was unable to return to work from February 2010 to February 2011, and that he would not attend the test because of his work restrictions and the rehabilitating program that he was involved in. In March 2010, the applicant's employment was terminated by the City, and he entered the Labor Market Reentry (LMR) program to continue his schooling. 10 months later, on January 12, 2011, the applicant filed another application 2010 allegations with the tribunal asserting that he was discriminated against by the City during the period of February 2009 to March 2010 with respect to 4 decisions made by the City, which include not providing accommodated work, providing unsuitable accommodated work, ordering him to attend meeting when he was physically not able, and terminating his employment. The City subsequently requested dismissal of the application because the applicant's submission was not timely and had no reasonable prospect of success. There are 3 issues involved in this case. First, should the allegations of discrimination be dismissed under Section 45, subsection 1 of the Human Rights Code? Second, should the 2009 allegations be dismissed under Section 33, subsection 1 of the Human Rights Code? Third, should the 2010 allegations be dismissed under the Rule 19A of the Tribunal's Rules of Procedure? The decision of the case is that the application was dismissed. The 2009 allegations were untimely, and the 2010 allegations had no reasonable prospect of success. Rationale to issue number 1. Dismissal under Section 45, subsection 1. In response to the policy grievance filed by the union, arbitrator Goodfellow released his decision on March 21, 2012. He suggested that the City change the work the worker needed to perform as accommodated work was not discrimination, and that the tasks performed by the workers were not any kind of position but only a side portion of a much larger work. It was not a case of discrimination because in February 2010, the City's work election process altered accommodation to employees with disability. Workers who receive accommodated work under the agreement were no longer entitled to the work they had been performing. It is disagreed that the allegations by the applicant were appropriately dealt with by arbitrator Goodfellow because the decision did not mention the 2009 and the 2010 allegations. According to Section 45, subsection 1 of the Human Rights Code, the Tribunal may dismiss an application in whole or in part in accordance with this rule if the Tribunal is of the opinion that another proceeding has appropriately dealt with the substance of the application. Thus, since the application was not appropriately dealt with by another proceeding, the application was not dismissed under Section 45, subsection 1 of the Code. Rationale to issue number 2. Dismissal of 2009 allegations for delay. Adjudicator Jennifer Scott decided that the 2009 allegations and the 2010 allegations were separate from one another because they were subject to different issues. One concerned the accommodator work that was not provided by the city, and the other concerned the participation in the annual work selection process. Also, the applicant could not provide reasonable explanation for the delay in filing the application. Thus, with regard to the application filed on March 8, 2010, the 2009 allegations were untimely and were dismissed. Rationale number 3. Dismissal of the 2010 allegations. During the 2010 work selection process, the applicant could have attended the meeting, but he did not inform the city of his availability. The reason for his absence was that he was attending an LMR program at the time, so it was not possible or important to accommodate someone in workplace who is unable to work. In legal terms, there is no duty to accommodate an employee who cannot work. Thus, the 2010 allegations were dismissed. Analysis of this case. The application was executed with accurate and logical reasoning under the condition that the application was filed out of time and no accommodations could be made to the applicant's work position. Although the applicant could have felt terrible facing his injury and the laid off, the law had not ruled in favor of one party, but rather investigated the application and issues involved without any bias. I believe that the government, the society, and some leading organizations should encourage employees to continue their work after temporary discontinuance of employment, reintegrating them back to the workplace. At the same time, the organizations should communicate with their employees, in particular those on temporary discontinued employment, to share personal plans in the near future, such as schooling and professional education that may hinder them from maintaining their workload, so that both parties can plan ahead of time. The survey question is, apart from the untimely submission regarding the allegations, do you think that the applicant should be offered accommodated work, the same position that he previously had after his injury when he left work for 2 years for physical rehabilitation and schooling?